Hello and welcome to the Introduction to Working with Unaccompanied Children. My name is Nadia Danilovich, and I'm a senior staff attorney at the Children's Immigration Law Academy, or CELA. This 101 webinar is being recorded on September 20th, 2023. It is one of a series of webinars we have available for advocates who are new to the field of children's immigration law. We will cover the basics of working with unaccompanied children and the experiences that these children have. So here is our agenda for today. I will explain who we are at CELA and what we do. I will review the profile of an unaccompanied child, including demographics. We will review the causes of migration. Then we'll turn to the legal protections available to unaccompanied children. And finally, we will review the current system that the children move through. If you are not familiar with us already, CELA is a project of the American Bar Association. We are an expert legal resource center. We are also a capacity building organization. We believe that every child should have representation and should not have to go to court alone. CELA originally started work in Texas and has now expanded to national work. We provide technical assistance regarding case-specific questions. We offer 5 national working groups centered around asylum, SIJS, pro bono coordination, detained work, and social work. And we still have one Houston-based SIJS group. The working groups are spaces for advocates to share and collaborate. We also provide trainings, both live and recorded, like this one, as well as written resources that we publish on our website. We host a platform featuring pro bono opportunities across the country and provide resources related to pro bono. In times with increased presence at the border, when emergency shelters have opened, CELA has also stepped up to help. We offer free resources on our website, cilacademy.org, and this includes a pro bono guide that details how to work with children and youth in their immigration cases. This is a really great resource, and we encourage you to check it out. So we're going to begin our work with an overview of working with unaccompanied children. You may already work in this field or are just starting out, or maybe you have never worked with unaccompanied children before, but you want to learn more. Maybe you want to take on a pro bono case or really help advocate in any way. So in a moment, I'm going to give you some general information about the children you are going to work with so that you have some tools for beginning to understand their experiences, and maybe even places to start when you are helping an adjudicator understand their experience, like an immigration judge, an asylum officer. However, I don't think we can really do that without first talking about cultural humility and empathy. I'd like you to consider this quote on the slide from Brene Brown. Empathy has no script. There is no right way or wrong way to do it. It's simply listening, holding space, withholding judgment, emotionally connecting, and communicating that incredibly healing message of you are not alone. Doing this work is going to evoke many feelings from you, and I hope it does. You want to remember that empathy is different from sympathy. You don't need to feel sorry for the children you work with, but listen, hold space for them, withhold your own judgment about what they're sharing with you, and communicate healing messages. There are webinars available on our site that go into more detail about how to interview and work with unaccompanied children, and I really encourage you to check those out if this is your first time doing that. A necessary part of this work is to also examine our own beliefs and cultural identities so we can effectively hold space for our clients and listen and understand their experience and culture without unconsciously imputing our own culture or beliefs onto them. Consider this quote on the screen as well. Cultural humility is a lifelong process of self-reflection and self-critique, whereby the individual not only learns about another's culture, but one starts with an examination of their own beliefs and cultural identity. Keep this in mind as we begin the work, as you view this webinar, and really throughout your work as you continue to grow as an advocate. So what do I mean by culture? Well, think about what culture means to you. Some key components of culture include shared beliefs, values, practices, customs, and social behavior. So, for example, I'm originally from Chicago, but I have lived in Los Angeles and currently live in San Francisco. So, Midwestern, Chicago culture definitely influenced my experiences growing up, as well as both Southern and Northern California culture have permeated my adult experiences. Additionally, my paternal grandparents were refugees from Poland and Serbia following World War II. So, in that way, refugee and immigrant culture permeated my family growing up. Race, gender, sexual orientation, religion, geography, and shared language may also all be part of someone's cultural identity. And this is a non exhaustive list. There are many things that go into culture. So, part of cultural humility is recognizing and understanding our own culture and then not letting that influence the way we are curious about our clients' experiences. So, for example, we should not assume that every child had the same resources we did to pursue education. In some countries, secondary school is not free. On the other hand, we should also not assume that just because a child grew up in another country, that they can't or didn't pursue educational opportunities. Cultural identities can also intersect and diverge. For example, you may be unaware that in Central America and the Caribbean, people can identify as both Latinx and Black, although those identities are not mutually exclusive. Not all Latinx people identify as Black and vice versa. So, if you have time, you might want to pause this recording right now and just jot down a few of your own cultural identities that you can think of. And then really think about a time when you made a cultural assumption, whether in work or your life outside work, a cultural assumption you made about someone else and that turned out to be wrong. And really examine that and reflect on that as you begin this work. So, practicing cultural humility is dependent on us also acknowledging and confronting our own implicit biases. I think we are all pretty well aware of what conscious bias or overt racism looks like, but implicit bias is a little harder to pin down. Implicit bias is made up of ideas that have been collected over a lifetime and stored in our brains from movies, culture, news, our experiences about religion, gender, physical ability, age, race, appearance, etc., all those things that can make up culture. And it's information that is biased. It's based on stereotypes that are largely false, but that have worked their way into our subconscious. It's usually about people who are different than us, who we don't know, who we might think of as other. And we all have it. It is really important to talk about it and not be fearful of talking about it. I encourage you to search for and take some free online implicit bias tests. Take time to reflect on those results and really think about how you can prepare for the work with unaccompanied children given your own implicit biases. Because really, once we recognize our own implicit bias, we can educate ourselves and then choose to act differently. So, to set yourself up for success in this work, it's also important to understand the legal terminology used. In this work, you will often encounter these 6 terms and more, but on the screen we have child, juvenile, minor, custody, alien, unaccompanied. So the term unaccompanied alien child was created in 2002 and is the legal term found in the Immigration and Nationality Act, also known as the INA. While we often have to use this legal term and others in government filings, we will discuss in just a minute why these terms are not inclusive and what words to use instead when talking about this work. It's also important to remember that as advocates who work within legal systems, we often are or become accustomed to all of the legal jargon, but our clients usually are not. And so it really is our ethical duty to ensure that we are communicating concepts to our clients in a way that someone who is not familiar with legal jargon will understand. So, like I said, that was legal language, but there's more inclusive language that we can use. Legal language can often be dehumanizing. It's not often inclusive. So, for example, the terms alien and illegal are really not words we should ever use to describe our clients. Humans are not illegal. Humans are not aliens. These words help to criminalize immigrants and other immigrants. Instead, what we can say is unaccompanied child, unaccompanied immigrant child, or child facing deportation. And we should speak about our clients this way even when they aren't present. Some legal terminology is also very clinical and not always inclusive of the diverse populations we work with. So instead of juvenile or minor, consider child, adolescent, teenager, youth. These are more inclusive, ambiguous, and again, just less clinical and cold. So now I want to share some statistics on global migration. So these charts and data come from the UN World Migration Report from 2022, which is published every 2 years, and a UNICEF report from April 2021, which will next be updated in December 2023 this year. So the chart on the left shows that while the international migration population has increased in size over time, it has actually remained relatively stable in proportion to the world's population. It tends to hover around 2 to 3%. And the chart on the right shows that the breakdown of data for international migrants based on age, so you can see the percentages globally. Most migrants tend to be between the ages of 18 to 64, so a minority are under 18, and that is the population we're working with. Now, the migration of children around the world is not new or unique to our present day situation. Child migration did not start in 2014 when we started seeing high numbers of Central American children fleeing to the United States. History has seen the displacement of children after World War I, World War II, the Russian Revolution, the Spanish Civil War, the Greek Civil War, famine in Ethiopia, in the aftermath of cyclical conflicts in Slavic states, and genocides in Rwanda. And this was just to name some historical events that have caused international and child migration. These infographics from the Migration Data Portal, last updated in 2021, show the percentage of worldwide migrants who are children and youth, worldwide and in the United States. The percentage of child migrants in the United States is currently just 7% of the worldwide population of child migrants. According to the United Nations World Migration Report in 2022, there were 281 million international migrants worldwide, and of those, 14.6% were children. This first chart on the left compares data from 2000 to 2022, taking into consideration different factors in populations. It shows globally that the proportion of international migrants who are children was 16% of the total in 2000 and 14.6 in 2022. So that actually went down some. But the total numbers have been on the rise, which you can see by the fact that there were 173 million international migrants in 2000 and now 281 million in 2022. And looking at the chart on the right, this is, again, migration data from UNICEF. You can see that the United States currently has the largest population of child migrants when looked at by country. And North America is home to about 11% of child migrants, or 3.3 million children under age 18 when looking at it globally. So where do the unaccompanied children that we work with come from? Well, the majority of them who are in the United States now are primarily from 3 small countries in Central America: Guatemala, El Salvador, and Honduras. And their square footage and mileage are listed on the slide based on each country. It's important to know that all 3 countries combined is really a total square mileage smaller than the state of Michigan. We just want you to consider that, to keep in mind that this is a really small geographic area where these children are coming from. This information is provided by the Office of Refugee Resettlement on a yearly basis, so you can look these up each year. And for the fiscal year 2022, ORR reported that 47% of kids were coming from Guatemala, 13% from El Salvador, 29% from Honduras, and all other countries, 11%. So given these statistics, it's important to educate and familiarize yourself with the history and cultures of these 3 countries in particular, as well as the root causes of migration from this part of the world. However, it's important to not forget that 11% of unaccompanied children do come from other countries, a number that has actually been growing steadily over the years. So it can be easy to fall into the routine of thinking solely about the unaccompanied children coming from Central America, but it's really important to be ready to work with any child. ORR does release yearly data on the breakdown of unaccompanied children by gender and age. And The statistics on gender have stayed relatively stable over time. Roughly two-thirds of unaccompanied children identify as male and one-third as female. And the overwhelming majority of unaccompanied children are between the ages of 15 and 17 years old. They make up a combined 77% for this combined age group. And younger children, usually under the age of 14 or 13, are often referred to as tender age. And you may see them especially when they are separated from a parent or a caregiver who they traveled with but are not related to. Unfortunately, there is no race or ethnicity data available from ORR, only country of origin. However, race and nationality are protected grounds for asylum, and together these often capture an individual's ethnic identity. This gap in data does not do justice to the racial and ethnic diversity of unaccompanied children from Central America and the rest of the world. We want to encourage advocates to not shy away from talking about race because it may be an important cultural identity for your client. If you are not curious about their racial or ethnic identity, you could be overlooking a possible asylum claim. The majority of data on race and ethnicity in Central America has to be collected and compiled from multiple sources. So here are just a few facts I pulled to give you an idea of what identity groups exist in Central America. So in Guatemala, there are approximately 22 Mayan languages spoken by indigenous speakers. In Mexico, about 6% of Mexicans speak an indigenous language. El Salvador actually ranks as having the highest percentage of multiracial identities in the Americas. And in Honduras, the Garifuna people are of mixed African and indigenous American ancestry, with the majority residing in Honduras and then Belize, although they do live in all of the Central American countries as well. So we know that migration has been happening since the beginning of time, but the rise of unaccompanied children migrating to the United States specifically has really been unprecedented, especially in the last 5 years. So what's the reason or the cause for all of this? Well, the circumstances and reasons are many. So some of those include that many of these children are experiencing or witnessing excessive violence in their communities. They are coming from countries where homicide rates rank among the top 5 worldwide. They are coming from communities that have been overtaken by criminal gangs. And many of them face extreme poverty and may feel that this is the only option they have to help themselves or their families. Employment is difficult to come by in some of these countries. And even if they are lucky enough to find a job, pay is often extremely low or unreliable. Some children are also fleeing a stressful or abusive home environment. Many flee due to abuse, violence, or discrimination against them based on their gender identity. Some from vulnerable communities, such as LGBTQIA+ youth and indigenous communities, are fleeing discrimination, marginalization, and abuse. Some of this is even perpetrated by their own families, their communities, and even from their own governments. In recent years, natural disasters, such as hurricanes, earthquakes, fires, have also prompted migration. Natural disasters are unfortunately becoming more frequent and more intense with climate change. And we unfortunately do not have that as a protected ground for asylum claims at this time. Extreme drought is affecting crops and livestock in Central America. And unlike some of the farmers here in the United States, they do not have the privilege of having their crops or livestock insured. So for many who take this journey to the United States, it's the journey of a lifetime. It's the journey for their life. This is one of the biggest things that is happening in their life, that they've usually made the decision to come here and better their lives in some way. And I just want to note the most recent statistics for this year is that 109,298 unaccompanied children have arrived at the southern border as of July 2023. And obviously that number is still growing as we move through the year. So children's reasons for leaving are often multifaceted. It's not just one reason from that list I just went through. And this chart on the right from the UNHCR report, Children on the Run, documents the journey of 404 unaccompanied children. And all of those intersecting circles in the middle show where the reasons intersect, compound to cause their migration. So sometimes a child might express to you one reason the first time they talk to you. And as they build rapport with you, they'll begin to share more reasons. So, for example, at first, they might share that they left their country to reunite with family here in the United States or have better educational and work opportunities. Maybe that's all they feel comfortable sharing with you. But later on, you might learn that the child was actually being recruited, threatened, or hurt by a gang, by a family member, a caregiver, or they may have been the victim of human trafficking. Trust takes time, and you will likely find that the more time you take to build rapport, the more your client will eventually open up to you about all of the reasons they had to leave home. So, what are some of the challenges the children will face once they're here? Because even though they faced challenges at home along the journey, there's new challenges to be met in the United States. So, unfortunately, their challenges don't disappear. Any traumatic stressors they had from before can continue to have a negative effect on their mental and behavioral health. Some will unfortunately experience depression, anxiety, PTSD, grief and loss, and these are just to name a few. In addition, they're dealing with the ramification of emotional and psychological trauma. These children also confront other risks to their well-being, such as separation from a parent or family member, sometimes long stays in the shelters. Some of them will face discrimination and bullying, abuse and neglect by their sponsor or others, and some will even endure human trafficking in the United States. And the resources that exist are limited, and sometimes there's also a stigma to ask for help in these children's communities. And so we come in as their advocates to really help them navigate the complicated system and challenges they will face. So who is an unaccompanied child? We covered this briefly when I was going over legal jargon, but it's really important to dive deep and understand the legal definition. And you'll see from the title, we've crossed out the word alien because, as I mentioned, it's dehumanizing. We prefer unaccompanied child, unaccompanied immigrant child. So the term is defined by the Homeland Security Act of 2002 and referred to by the Trafficking Victims Protection Reauthorization Act of 2008, known in this line of work as the TVPRA. And it defines unaccompanied child as being under 18 years of age with no lawful immigration status and no parent or legal guardian in the US available to provide care and physical custody. And these elements really refer to the time when the child is apprehended by Customs and Border Patrol, CBP, at a border or at an airport. So in other words, it's a child who enters the United States without valid entry document. They are not a US citizen, LPR, they don't have an approved visa, and they're not accompanied by a parent or legal guardian when they are trying to enter. Oftentimes, this determination that a child is an unaccompanied child is made by that CBP officer at the border, but it really can be many other government officials as well, one of those being USCIS, which we will talk about more later. Being designated an unaccompanied child brings with it legal protections from these main sources of law. So we have the Flores Settlement Agreement, which was approved by the U.S. District Court of the Central District of California in 1997. And it came about after children in immigration detention were experiencing horrible conditions. And it really aims to improve the treatments of minors in detention. So one thing it says is that children must be in the least restrictive setting available, and that the facilities must be licensed by the state. We also have the Homeland Security Act of 2002. This created some protections and, like I said, defined the term unaccompanied child. It ended the INS, which you may have heard of, the Immigration Nationality Services, and it created new entities, new agencies. And one of those was HHS, and under that ORR, the Office of Refugee Resettlement. And that is the agency that houses unaccompanied children in the United States. This act also created the Child Advocate Program and, like I said, defined unaccompanied child. Then we have the Trafficking Victims Protection Reauthorization Act, the TVPRA of 2008, and that enshrined and also expanded further protections for unaccompanied children. It guaranteed that unaccompanied children will be placed in removal proceedings so that they can fight their case instead of being automatically sent back to their countries. And it also provides opportunity for unaccompanied children to present their asylum claims in a non-adversarial setting at the asylum office. So we're going to dive deeper into each of these. So more on Flora's Settlement Agreement, or the FSA. So this started all the way back in 1984. Advocates sued INS over their policy to release children only to parents or legal guardians, and also over the horrible detention conditions. What was happening was the INS was commingling children of all ages, all genders. They provided no education during the children's time in detention. There was no recreation time, no visitation, and children were even subjected to strip searches. So the advocates sued, and the settlement agreement was approved by the court in 1997. And it remains good law today, which may seem odd because it's a settlement agreement. So why is this the case? It's because the agreement would only end when regulations were promulgated by the government. And more than 20 years later, no regulations have been promulgated. There have been many headlines, especially over the last 5 years, about the detention and conditions of unaccompanied children. And it's really great that we have all this news coverage and attention on the issue, because we want to highlight that the system still has a lot of room for improvement. You know, it's always important to keep the historical context of where we came from, but we should also always be striving to improve the conditions, improve the system. So at the time the FSA was proposed, there was also a motion to enforce compliance of that agreement pending before the court. The agreement set out a nationwide policy for the detention, release, and treatment of minors. So let's start with one of the provisions that is most cited out of the FSA, the requirement that the child must be in the least restrictive setting. So what it says is that the INS shall place each detained minor in the least restrictive setting appropriate to the minor's age and special needs, provided that such a setting is consistent with its interest to ensure the minor's timely appearance before the INS and the immigration courts, and to protect the minor's well-being and that of others. So the requirement is not universal, and it does have some balance to some of the government's stated interest. But it does make clear that children should be placed in the least restrictive setting with the least security necessary to ensure their safety and others. It also focuses on apprehension. So when a child is taken into custody, the government must provide the child with a notice of their rights. Facilities must also have access to toilets and sinks, clean drinking water and food, medical assistance, adequate temperature control and ventilation, adequate supervision of the children, and contact with family members that they may have been apprehended with. The children must be segregated from adults, and they must be transferred to a placement within ORR within 3 days, unless there is an emergency or an influx situation. The agreement requires a plan for when there is an emergency or an influx situation. And finally, if the government believes that the person is an adult, despite claims they are a child, they can be treated as such and can submit the person to a medical or dental exam. So overall, from the FSA, we have a general policy favoring release. If detention is not required to secure the timely appearance in court or for the child or other safety, the government needs to release the child. The list of preferences for the sponsors for the child is a parent, a legal guardian. Next would be an adult relative, or an individual designated by the parent or legal guardian, a licensed program, or other adult where family reunification is not possible. A suitability assessment, also known as a home study, may be required before the child is released to that sponsor. And family reunification efforts shall continue as long as the child remains in custody. So, custody, there are secure facilities contemplated for certain children, such as those with delinquency or criminal convictions, those who are an escape risk or are generally disruptive. There are also medium security facilities and higher security facilities, which we'll talk about later. Transportation, unaccompanied minors should not be transported with adults. Transfer, if they're being transported between places or placements, their counsel, their attorneys must be notified of the transfer with advance notice unless it's for the safety of the child or others, in which case notice must be provided within 24 hours after the transfer. The FSA also created a structure for ongoing monitoring and reports. There's statistical information that must be gathered and maintained. Release decisions can be questioned by counsel, especially if a child's release is being denied, and compliance with the agreement shall be reviewed periodically. The FSA also covers attorney-client visits. Attorney-client visits are allowed. There are some special provisions for the counsel involved with the lawsuit also to assure compliance with the agreement. So the FSA is still in force today. As I said, you can find the regulations on the detention and release of juveniles at 8 CFR 236.3. And these regulations are essentially the same regulations that were once at 8 CFR 242, which were initially promulgated in 1988. Regulations to cover the terms of the settlement were proposed in 1998, but still never promulgated. Since 1997, the attorneys who brought this litigation have filed numerous motions to enforce the terms of the settlement when the government is violating the settlement agreement. In 2015, the court ruled that the government's family detention policy violated the FSA. While this doesn't necessarily cover unaccompanied children, it isn't good to know about how the FSA can also apply to non-accompanied children, accompanied children who are with their families. In 2017, the judge ruled that the government had been failing to comply with the FSA, especially regarding inadequate food, lack of clean water, unsanitary and unsafe conditions, and inadequate sleeping conditions. The judge appointed a juvenile coordinator to oversee the government's actions to comply with the agreement. In September 2018, the Trump administration proposed regulations that sought to essentially terminate the Flores Settlement Agreement's legal safeguards for unaccompanied children, including the provision that they should be transferred to non-secure licensed facilities within 3 days of apprehension. And it proposed regulations that included a number of policies, which, if implemented, would allow the government to incarcerate more families for even longer periods of time. So that was in 2018. In June of 2020, due to the COVID-19 pandemic, a district court judge ordered that all children currently held at ICE family residential centers for more than 20 days must be released. In September of 2020, the U.S. District Court for the Central District of California ordered the government to stop placing minors detained by the Department of Homeland Security, DHS, pursuant to a public health order under Title 42. And the court ruled that DHS cannot be placing children in hotels during this time. The court further ordered that DHS may implement brief hotel stays for minors of no longer than 72 hours as necessary in good faith to alleviate bottlenecks in the intake processes at licensed facilities, but it did need to stop housing unaccompanied minors for long periods of time at hotels along the border. In June of 2021, the court affirmed the district court's ruling requiring DHS to apply the Flores Settlement Agreement to minors detained in hotels for more than a few days, as the government was trying to argue that the settlement agreement did not apply to those children. But even though they were not in licensed OR facilities or CBP holding facilities, the placement of these children in hotels, they were still covered by the FSA. And finally, in December 2021, the Biden administration announced they were no longer seeking to terminate the Flores Agreement through the 2019 Trump administration rules. So that brings us to 2022. In May of 2022, after 2 years of negotiation, the parties submitted a joint motion for preliminary approval. It focused on the RVG and El Paso sectors of the border, and it required CBP to designate at least 2 specific facilities as juvenile priority facilities. CBP agreed to a wide range of protocols that require minors to be held in safe and sanitary conditions. This includes access to showers, age-appropriate meals, clothing, mattresses, blankets, medical care, and much more. CBP also agreed that they must treat minors in custody with dignity, respect, and special concern for their particular vulnerability as minors. They affirmed that they must be placed in the least restrictive setting and remain with family members except when not feasible. In June of 2022, the parties also submitted a proposed stipulated settlement following a motion to enforce the settlement agreement at emergency intake sites. So it required that there be suitable living conditions at these emergency sites, daily outdoor activity, private phone calls for 10 minutes at least twice a week to family members, and weekly meetings with case managers. And it also prohibited the placement of particularly vulnerable children at emergency intake sites. And later on today in this presentation, we'll cover more about what these emergency intake sites are. But really what's important to know is that the Flores Settlement Agreement does apply to all unaccompanied children, whether in CBP custody, whether in hotels, whether in emergency intake sites, whether in OR custody. And advocates should really look to the Flores Settlement Agreement when there are conditions that are not being met and when rights are being violated. Okay, we're going to turn now to the Homeland Security Act of 2002. So as I mentioned earlier, as a result of the HSA, the government changed who takes care of the children from INS to the Department of Health and Human Services, HHS, and within that, the Office of Refugee Resettlement. So this was at the same time the INS moved or became the Department of Homeland Security, and we have all of our current enforcement agencies under that umbrella. So we have USCIS, which is U.S. Citizenship and Immigration Services, U.S. Customs and Border Patrol, or CBP, U.S. Immigration and Customs Enforcement, or ICE. And so in your work with unaccompanied children, you will often encounter one, two, or all of these agencies. So it's really important to understand the structure and what umbrellas they fall under and who they report to. This Homeland Security Act of 2002 also led to the creation of child advocates. So these are different than attorneys, than paralegals, caseworkers. You may be familiar with the Young Center already or learn who they are through your work, but they are child advocates who are appointed to look out for the best interests of the children that we work with. As we've mentioned, it defined the term unaccompanied child and solidified that this could be a status designated by any government agency, including CBP, USCIS, and ICE. This designation should apply to all detained children you work with, although there can be issues where the government is alleging the child is not an unaccompanied child or is no longer an unaccompanied child. All right. This is just another way to visualize all of the stakeholders you need to be aware of and you'll likely encounter in this work. So this graphic comes from our website in our resource, Who's Who in the UC World, a guide to identifying and working with stakeholders. These materials can be really helpful, especially if you're new and entering this work. And I encourage you to go to our website, download it if you have not had a chance to view this already. So, we already went over HHS, DHS, all of its subparts, but there's some other stakeholders involved in the process. So some children actually have to go into state courts in addition to immigration court. And this is if they're eligible for special immigrant juvenile relief. And for that to be obtained, one of the first steps is going into state court to get a state court order. As I mentioned, you might encounter the Young Center. They're an independent nonprofit organization that helps children get an appointed child advocate. They focus on the best interests of the child, whereas legal advocates focus on the stated interests in the legal case. And you may encounter other nonprofits or groups working for the government or on behalf of the child. There really are so many stakeholders in this world, so it's good for you to familiarize yourself with them. And finally, we've come to the last major source of protections for unaccompanied children. The TVPRA is a bipartisan legislation passed in 2008. You can find section 235A, B, and C codified at 8 U.S.C. 1232. And what this does is it combats child trafficking at the border and ports of entry. It encourages policies and procedures from several executive departments for ensuring safe repatriation of children. So if there are children who want to return to their home country, that is enshrined in this legislation that the government needs to ensure that that is safe for the children and that it happens. There are special rules for children from contiguous countries, so from Mexico and Canada. If the immigration officer encounters a Mexican or Canadian child entering the country, they will be turned back unless they're a victim of human trafficking or there's credible evidence that they are a victim, even if that can't be established for sure. If the child has a fear of returning owing to a credible fear of persecution, so an asylum claim, or if the child cannot make an independent decision about entering this country and then withdrawing their application for admission. So any child who really falls into a vulnerable group who needs extra support, these children are all exempted from being sent back automatically, and they would be put into the ORR system. So another thing the TVPRA does is ensure that children get put into removal proceedings. We'll go into this more later, but this is actually a benefit, a protection, and it is a way for children to obtain voluntary departure if they want to return to their home countries. It's not a removal order, not a deportation order, and if they're still detained when they request this, it will be funded by the government. The TVPRA, like the Flores Settlement Agreement, goes into the care and custody of unaccompanied children. It reiterates that care and custody is the responsibility of HHS. It requires a notification to ORR within 48 hours of apprehension of the unaccompanied child at the border, and then requires that children be transferred to ORR custody within 72 hours. And it also lays out procedures for age determinations, especially if there's a question as to the child's age or whether they are a child or an adult. It also called for policies and programs to protect children from trafficking. It reiterated the need for safe and secure placement in the least restrictive setting possible. And it specified that placement in more secure facilities must be reviewed on a monthly basis. And it requires safety and suitability assessments of the potential sponsors. So if a child has identified a sponsor they want to be released to and live with, it's the government's responsibility to inquire into the capability of that person to provide and care for the child. It allows them to do home studies for certain sponsors. It also created legal orientation presentations for some sponsors. This was handled by EOIR, the Executive Office for Immigration Review, which is also just known as the Immigration Court. And certain immigration courts around the country will host legal orientation presentations for the sponsors to understand why the child needs to appear in court and how it works. It also covers access to counsel, so it ensures that to the extent practicable and consistent with the right to counsel statute, that all unaccompanied children have counsel to represent them in legal proceedings. While this is stressed, we'll get into later about why not all unaccompanied children are represented in court. It also touched on child advocates, stressing that child trafficking victims and other vulnerable unaccompanied children should get child advocates to represent their best interest. It also expanded protections and eligibility for SIJS, Special Immigrant Juvenile Status, and it created asylum protections for unaccompanied children. So it stated that the safe third country exception does not apply. So usually if a person is seeking asylum, they will be ineligible if there is a safe third country where they could have lawful status. The one-year filing deadline does not apply to unaccompanied children. Unlike everyone else, they don't have to apply within 1 year of entering the United States. And it gave initial jurisdiction of unaccompanied children's asylum applications to USCIS. And we'll go over that later as well. Now, it may seem counterintuitive, but like I said, it's actually a benefit and a protection for unaccompanied children to be put in removal proceedings. Many adults and families that arrive at the border, they don't ever have the opportunity to speak with an immigration judge. They have to either pass a credible fear interview, also known as a CFI, and if they don't, they are expeditiously removed from the country. So being in removal proceedings means that all unaccompanied children get the chance to talk to an immigration judge and present evidence that they are eligible for legal relief to stay in this country. In other words, they get a chance to fight their case. However, there is no right to appointed counsel. We'll go over that in just a minute. Immigration judges also have the authority to reevaluate the designation of unaccompanied child status. So even though CBP or USCIS or ICE may designate a child as an unaccompanied child, immigration judges do have the authority to reevaluate and even de-designate children. The judges will also assess removability and eligibility for relief from removal. And in addition to applying for legal forms of relief for their clients, lawyers and accredited representatives can raise procedural challenges. So I also encourage you to check out the immigration court's memoranda on their website. They have many directors' memoranda and policy memoranda. Here on the screen, we have a screenshot of some of the ones that are applicable in this work with unaccompanied children. There's a memorandum on the role of child advocates in immigration court, on language access, the status docket, which children can be placed on, and friend of court, which comes up frequently for detained children. So as I just mentioned, unaccompanied children do not have a right to appointed counsel like they do in other civil proceedings in the United States. So here are the basis of legal protections regarding representation. HHS is to develop a plan to ensure that qualified and independent legal counsel is timely appointed to represent the interests of each child detained by the federal government. HHS is to ensure to the greatest extent practicable that all unaccompanied children who are or have been in the custody of ORR and DHS have counsel to represent them in legal proceedings or matters and protect them from mistreatment, exploitation, and trafficking. To the greatest extent practicable, the Secretary of Health and Human Services shall make every effort to utilize the services of pro bono counsel who agree to provide representation to such children without charge. A person in removal proceedings shall have the privilege of being represented at no expense to the government by such counsel who is authorized to practice in such proceedings. So what does all of this mean? This means that unaccompanied immigrant children have the right to find and hire or retain a pro bono lawyer, but it is not the government's burden or responsibility to find and appoint those lawyers for unaccompanied children. The only case where this does happen is for detained children. And even then, as you can see, the buzzword here is when it's practicable for the government to do so. So some unaccompanied children will spend enough time in detention or our shelters that they will need to appear in immigration court before they're released to their sponsors. In these cases, the unaccompanied children will have representation either through limited appearances from the legal service provider attorneys or as friend of the court when the immigration attorney from the local nonprofit will come to court with the children and kind of act as an intermediary between the child and the immigration judge to help facilitate the movement of the case, but they aren't actually representing the child or making substantive decisions and actions in the legal case. So I want to mention that having access to counsel makes a huge difference in children's cases. Statistics from 2014 to 2015 showed that 84 to 89% of represented children were able to pursue legal relief and remain in the United States, while only 9 to 16% of unrepresented children were able to stay in the country. And for cases in the first few months of 2016, the contrast between the represented and unrepresented children remained extreme, 50% compared to just 9.5%. So this really shows us that having an attorney who can identify appropriate legal claims, such as asylum, special immigrant juvenile status, it just increases the odds by so much that a child will be able to stay in the United States. All right, so as mentioned, the Asylum Office has jurisdiction for unaccompanied children, and this is a huge protection and benefit. So this is often referred to as the first bite at the apple. So even though unaccompanied immigrant children are in removal proceedings, before the immigration judge or the ICE attorney is trying to fight to deport them, unlike adults in family units that are in immigration court in removal proceedings, unaccompanied children get a first shot at the asylum office. And this is huge because the asylum office is non-adversarial. It's an interview setup, it's one-on-one, the officer is asking questions of the child, but there's no ICE attorney there arguing against the child's case. And if they aren't successful at the asylum office, they're not immediately deported or receive a removal order. Their case is just referred back to immigration court and they get a second chance to present the case before the immigration judge. They get time to work on their filing, gather more evidence, and this is just really such a huge protection for children. So there have been many updates over the years about how USCIS determines whether they are interviewing an unaccompanied child and thus have initial jurisdiction. So prior to 2013, asylum officers would ask questions at the beginning of every asylum interview with the child to determine if the child was an unaccompanied child. And this was a confusing process that was not consistent, not uniform across the country, and it resulted in sometimes in unaccompanied children being denied an interview, usually if they had turned 18 or now resided with a parent or legal guardian since they initially filed their asylum application. So in 2013, USCIS issued the Kim memo, which establishes that USCIS would defer to any prior agency determination of UC status. So if CBP, ICE, ORR had already determined the child was an unaccompanied child, USCIS would not question it. So they didn't have to take up time at the beginning of every interview to decide if the child was an unaccompanied child. It shortened interview times. It resulted in USCIS still retaining jurisdiction over children who are 18 plus or reunited with families. And so this is how it operated from 2013 to 2018. In 2018, during the Trump administration, the Board of Immigration Appeals, so BIA, they issued a ruling that authorized immigration judges to de-designate unaccompanied children after they turned 18. So some advocates can read this case as permissive, not mandatory, and we encourage that interpretation. Some judges will continue to grant continuances to children who are 18 or older instead of forcing them to proceed at a merits hearing in immigration court without getting that first bite at the apple at the asylum office. So unfortunately, along these same lines, in 2019, USCIS issues the Lafferty memo, which would return to making UC determinations at the start of every asylum interview, pre-Kim memo, and would refuse jurisdiction to children who were 18 or older or reunited with family. In 2019, advocates in the immigration community sued DHS over this policy, and so far they have been successful in that the judge certified a nationwide class and granted a preliminary injunction enjoining the government from applying the Lafferty memo. So at this point in time, at the time and date of recording this webinar, this case, JOP versus DHS, is actually still pending. And until we get a final decision, advocates can operate under a 2021 memo that instructs USCIS to accept UC applications filed at service centers as long as they provide certain evidence of their UC designation, their UC status. I want to touch briefly on some sources of law in addition to all those protections we just covered. Unaccompanied children have primary sources of immigration law. There are several sources that we refer to. So statutes, which can be found in Title 8 of the US Code and the Immigration and Nationality Act. These are promulgated by Congress. Then we have regulations, which are in Title 8 of the Code of Federal Regulations. These are created by the agencies like ORR, DHS, EOIR. We also have policy and guidance memorandum for immigration agencies. This is also from the agency. So like I mentioned, those memos about asylum jurisdiction from USCIS, this is what that falls under. And then we have case law, which comes from the courts. We have the immigration courts, we have the Administrative Appeals Office, the Board of Immigration Appeals, and then above that, circuit courts and the US Supreme Court, which occasionally weighs in on immigration issues. So now that we've covered the legal protections afforded to unaccompanied children, we'll turn to the system that the children find themselves in. So this chart on the screen shows the number of encounters or apprehensions by CBP of immigrants at the southwest border. So this is all immigrants, children, unaccompanied, accompanied family units, single adults, and it's broken down by month, with July 2023 data being the most recent, and it's also broken down by year. So you can see that migration dropped significantly in 2020 due to the onset of the COVID-19 pandemic. During this time, Title 42 was used to address public health and social welfare and it granted the government the ability to take emergency action in numerous ways, including to stop the introduction of communicable disease. So while this code had been in place for decades, it had rarely been used, and it really was widely used at the start of the pandemic in March 2020, when the administration began turning away immigrants, including asylum seekers, at our borders. So for a while, unaccompanied children were included in this. Everyone was being turned away at the border, and the number of children in OR custody was going down. But in 2021, unaccompanied children were exempted from the policy and were let into the country and placed back in OR shelters. And finally, in 2023, the administration ended Title 42 for adults and family units as well. So these two charts look specifically at the apprehensions of unaccompanied children at the southwest border. So while the first chart looks somewhat similar to the chart on the last slide, you can see that unaccompanied children numbers really spiked in 2021 when they were exempted from Title 42. And 2022 and 2023 have evened out more while remaining high overall. And the bar graph on the right is just another way to visualize how few unaccompanied children were allowed into the United States in 2020 versus every year since then. And as you can see, 2023 is still climbing and will probably be somewhere around the 2021 and 2022 levels. So after a child is apprehended by CBP at the border, they're taken to a Border Patrol station where they are questioned. And this is a picture of a typical Border Patrol station holding area. Children are grouped together, sometimes in crowded spaces, like this picture. They're given blankets, but almost all of the children tell us these are ineffective at keeping them warm. There is cold air being blasted 24/7, and that's why these facilities have actually become known as hieleras, or ice boxes. And an AI Justice report on human and civil rights abuses in the hieleras, it's from 2013, but it remains relevant today. And it says, while detention in CBP holding cells is supposed to be temporary, persons we met with have been detained there for as long as 13 days. Detainees' fingers and toes turn blue and their lips chap and split due to the cold. Blankets were not provided, and there is a single sink and toilet in plain view. Sleeping on the cold floor is even more difficult because bright overhead lights are left on 24/7. We've also had unaccompanied children report that the food they were given was cold, was spoiled, was rotten. So this report, all the reports of horrible conditions at the border, precipitated a lawsuit, and there are other lawsuits around the country on the same issue. So the American Immigration Council found similar conditions in the Tucson sector of the Border Patrol facilities, and they noted in their press release that much of the evidence that remains under seal was submitted in the case only after the court sanctioned Border Patrol for destroying video recordings from these facilities and failing to turn over other relevant documentation. So we know that CBP was, in fact, trying to destroy evidence of the horrible conditions that existed at the border. So while this has improved over time, it's always important to ask children about their experience in the detention facilities prior to arriving in OR custody and being released to sponsors. And this is both so we can collectively hold the government accountable, but it's also to see if any action should be taken after the fact to help your client. So here's a way to visualize the physical journey an unaccompanied child takes through the system. So like we said, the first experience in the United States is that apprehension by CBP. Oftentimes we hear that children even are looking to turn themselves in to the CBP officials once they cross between official ports of entry. So children may be apprehended at a port of entry or after crossing the border between these official ports of entry, or even at an airport if they were able to fly in, but maybe their visa was invalid or it's now being questioned. And before the pandemic, there was a widespread practice called metering on the Mexican side of the border. This meant that the United States would only allow in a certain number of asylum seekers a day, even though that's not the law, that any asylum seeker is supposed to be processed into the United States. But what happened is this metering really affected unaccompanied children who couldn't even get on that list most of the time and were often taken into custody by Mexican child welfare agencies and then deported back to their home countries before they even got into the United States to seek asylum. In 2021, with the onset of the COVID-19 pandemic, as I mentioned, the government used Title 42 to stop all entries into the United States. In 2021, we had that exemption for unaccompanied children, and Title 42 ended in 2023. Once children are apprehended by Border Control, they are taken to a CBP holding facility, as shown on that previous slide. And children who are identified as unaccompanied are then transferred to an Office of Refugee Resettlement facility. By law, this is supposed to happen within 72 hours, but it's important to note that there is an exception in the law that CBP can argue that they need more time in the case of emergencies, or especially when numbers of children entering at the border spike. It's also important to note that to the extent a child is separated from their parent for any reason, they may then become identified as an unaccompanied child and sent to an OR shelter, even though they entered with a parent. Now, while family separation as a policy and issue was most relevant in 2018 during the Trump administration, advocates continue to see cases of this today. It's important to be on the lookout for children who were potentially separated from their parents. Additionally, children who travel with a caregiver who is not their parent or legal guardian, like an adult sibling or a grandparent, they will be separated from that person, unfortunately, and identified as an unaccompanied child and have to go through the ORR system. So when the number of children arriving at the border has been very high, influx and emergency shelters have opened to take in these children, in addition to the regular OR shelters. Eventually, most children will be released to a sponsor, transferred to long-term foster care or URM programs, released on their own recognizance upon turning 18, or transferred to ICE custody upon turning 18. And we'll talk about all of this more in just a minute. As of September 2023, there were approximately 296 OR facilities in the United States. And this number changes, but it really has gone up drastically over the last year. As of September 15th, 2023, there were 10,419 children in OR care. Texas is the state that receives the most children and has the most shelters. Texas currently has about 52 ORR shelters. After that, most unaccompanied children are released to California, Florida, and New York. And the average length of time that unaccompanied children spend in OR custody, it does fluctuate, although it tends to hover around 33 to 46 days. ORR is, of course, notorious for changing release guidelines, so that really is what impacts the difference in length of stays. When there are more stringent requirements on the sponsors that the children want to be released to, that inevitably prolongs their time in OR custody. Now, the number of children that are apprehended at the border is greater than the number of children who are transferred to OR custody. And that's because there are those different standards for Mexican and Canadian children who, if they can't show a fear of return or that they were trafficked, those children will automatically be sent back. The ideal situation is to reunify all these children with a loved one. But if there's not an immediate family member in the United States that can take them in for whatever reason, then the goal is to place the child in the least restrictive setting, that term I keep mentioning. So again, extended family, family friends, and if necessary, foster care situations. There is an initial danger safety assessment that determines what kind of facility the child will go into. And in just a second, we'll go over all the different kinds of OR shelters. So there are many different types of OR shelters. Starting on the left, we have regular shelter care. This is the most common. This is where most unaccompanied children go to. ORR has minimum standards and state licensing standards and local regulations that they have to apply for all these OR facilities around the country. And they contract with local nonprofits to run these shelters under their guidance. Next, we have transitional or short-term foster care, also referred to as TFC. So this is typically for vulnerable unaccompanied children. They can be children under the age of about 13 or 14. They could be pregnant or parenting already. Maybe the child has special needs. And these children in TFC are placed with foster families that are managed by ORR. So they're not in a shelter. They live with foster families, and during the day, they often come to an office or shelter setting where they take classes. The next type of shelter is called staff secure, and it's considered a step up in security level from that regular shelter care. This is for children who require closer supervision. Children can be stepped up when they are considered unexcessively disruptive, have a possible gang affiliation, perhaps committed nonviolent crimes, some drug use, maybe they've displayed some violence, or maybe they're just considered a flight risk. There's a concern they're going to run away from the shelter before going through the process to be reunified with their sponsor. Now we have secure, which is the highest level of security. And children are put into secure shelters when they are a danger to themselves or others, when they have been charged or will be chargeable with a criminal offense. And advocates have really fought hard to end the use of these facilities. They are rampant with abuses and violations of rights. And advocates have been successful throughout the years in shutting down certain secure facilities, although some do continue to exist. The next type of shelter is called residential treatment centers, or RTC. And a child can be placed in an RTC when they have been determined to be a danger to self or others by a licensed psychologist or psychiatrist. And during the Trump administration, many of these were shut down or phased out of use. And they were often rampant with abuse and violations, just like the secure facilities. Again, advocates have filed lawsuits over these conditions, some around the use of forced psychotropic medication, and advocates have been successful in many of these areas. As mentioned, there are also influx or emergency intake sites, known as EIS, and these are used when there's spikes in the number of unaccompanied children entering the country. So when capacity is filling up at the regular shelters and the government needs more space quickly, they open these emergency sites. However, these sites are problematic because they usually don't get state licensing because they're opened usually on federal land, and they're so last minute. They're emergency shelters. Now, the government says they're intended for children 14 or older, only Spanish or English speakers, so no indigenous language speakers, and no child who has medical issues or special needs should be placed in these emergency intake sites. But in practice, advocates have seen the government break all of these guidelines. And additionally, there have been reports about the lack of background checks and screening done for staff, which can result in abuses and violation of rights. Second to last, we have long-term foster care. You'll hear that referred to as LTFC. So this is intended for children who don't have an identified or an approved sponsor. So usually once their caseworker in the shelter has really exhausted all options for trying to find and approve a sponsor for them. In the past, children had to qualify for legal relief. So an attorney at a legal service provider had to find that the child was eligible for asylum, SIJS, so T visa, before they could be admitted to the program. But now that requirement has been done away with. Children in long-term foster care are placed with foster families for long-term care or sometimes in group homes. And children can stay in LTFC until they turn 18. Finally, we have URM, the Unaccompanied Refugee Minors Program. So this is also intended for long-term care for those without sponsors. The difference being that to get into this one, children must have been granted legal relief or belong to certain special categories that we'll get into. These children are also usually placed with foster families, sometimes in group homes, and they can stay here until 21. So often some children will go to LTFC first, while their case is still going, while they're trying to get asylum, and they're able to move into the URM program once they've been granted that legal relief. So, influx shelters and emergency intake sites. I've mentioned this, but we just want to cover it some more. During an increase in children arriving to the United States, ORR may fill up. It may not have sufficient bed space with the rate of how quick kids are getting released to sponsors, who's still in the shelters, and who's arriving at the borders. So the federal government will open these influx care facilities or emergency intake sites. And because of their temporary and emergency nature, they're often not licensed. They're often exempted from state licensing or local licensing agencies. And often these facilities may also be on federal properties, in which case, again, they're not subject to those state or local licensing standards. And legal service providers will try to serve the children in these facilities, and they have. But as you can imagine, they're temporary by nature. They're emergency sites. They come and go, they open and shut down. There aren't always set procedures and policies around that govern these emergency sites. And so it's always better for a child to be in a regular OR shelter if possible. All right. Turning to secure and staff secure shelters, there was an important case called Lucas R. v. Becerra, and it was a win for children in these types of shelters. So on August 30th, 2022, Judge Dolly M.G. issued a preliminary injunction requiring ORR to provide youth in federal immigration custody with due process. The court ruled that OR must provide clear and convincing evidence of sufficient grounds for stepping up a child or continue to keep a child in one of these restricted placements. So this includes secure and staff secure shelters. A notice of placement, known as an NOP, must be provided to the children, their parent or legal guardian, and their counsel within 48 hours of step up to these higher security shelters. ORR must also automatically serve a new NOP every 30 days to continue laying out the ongoing justification for why they need to remain in this higher level security shelter. And this injunction took effect last year in October of 2022. Within the population of unaccompanied children, there are often some pregnant teens, some who didn't know they were pregnant before they arrived, and unfortunately, some who became pregnant as a result of rape on their journey to the United States. So in 2022, ORR published Field Guidance 21. And what this field guidance does is it revises previous policies and procedures, it expands them to apply nationally, and it provides additional instruction to ORR staff about what to do when they encounter a pregnant child requesting an abortion. So OR must prioritize placing pregnant youth in shelters in states where abortion has not been banned. If a child is in a shelter where abortion is banned and then requests access to an abortion, OR must transfer that youth to another state to receive care. And the guidance also requires that ORR intake teams prioritize pregnant teens and act within state law regarding abortions. This revised field guidance also gives further guidance to staff on providing resources to pregnant youth. So after this field guidance was issued, there was a stakeholder call held by ORR. And during that call, they did confirm that service providers, the shelters, can qualify for an exemption if they have a sincerely held religious belief. ORR is aware of which providers currently qualify, but they have not published that list. So it's really incumbent on advocates who represent youth in states that ban or restrict abortion. It's our ethical duty to review and be familiar with this field guidance and use it to advocate for our clients, especially if they need to be transferred to another state. Unfortunately, abuse, including sexual harm in OR custody, has always been an issue. As such, it's important as advocates to familiarize ourselves with the issue and stay on top of reporting requirements. So the standards governing abuse in OR can be found at 45 CFR 411.11 and in the OR policy manual at Chapter 4, Section 3. So both sections lay out the zero tolerance policy that ORR has towards all forms of abuse, including sexual abuse. Section 4 of the ORR guide provides an outline for and guidance on ORR's approach to preventing, detecting, and responding to such conduct. ORR is required to have a written policy and employ prevention of sexual abuse PSA coordinators at both the headquarters level and the shelter level. At an OR stakeholder call, OR stated that they have added significant resources in 2022 to improve collection of data on abuse, and they are doing daily review of sexual abuse significant incidents reports, known as SIRs, and they're providing funding and oversight for on-site audits. They also shared that all sexual incidents are reported directly to state and local authorities. While it's hard to find consistent, reliable, and publicly available data, we did learn at a stakeholder call from ORR that there were 2,123 SIR allegations of sexual abuse from just January to August in 2022. Of those, 238 came out of the emergency intake sites, 247 came from influx care facilities, 208 came out of foster care, 19 from RTCs, 45 from secure placements, and about 1,300 from shelter programs. So this just really can show you the breakdown of where abuse and sexual abuse is happening throughout the OR shelter system. OR staff do have their own reporting guidelines, but we as legal staff must also follow our jurisdictional requirements. And if you're a lawyer, your state bar ethics rules. So for those in the VERA network, you can find VERA's guidelines on their SharePoint. They have guidelines responding to situations of abuse. And in some states, attorneys are mandatory reporters, while in other states, attorneys must weigh whether imminent harm to the child or others requires us to break confidentiality if we don't have that child's permission to report the sexual abuse. All right, moving on from that, what happens at the OR shelters? So you can see here that once a child is apprehended and determined to be an unaccompanied child, they're supposed to be turned over to OR care within that 72 hours. And when they arrive, they are given an assessment, a biographic intake, a medical exam, and a mental health evaluation. So there is a lot that happens for the children in those first days when they arrive at the shelter. In addition, legal staff from the local nonprofits, the legal service providers, come to the shelters to give Know Your Rights presentations and legal screenings, and those are supposed to be done within 10 days. OR then begins working with each child to identify a sponsor and go through that sponsor application and reunification process. If reunification is approved, the child is released to the sponsor, and that could be in a different part of the country from the shelter where they're detained. ORR maintains files of all the information collected on each child during their time in OR care, so it's recommended that legal advocates request those files once they're working with released children. Some children upon release are referred to legal service providers if there's capacity for pro bono representation. So this flow chart shows what legal services the children receive while detained. So as mentioned, they receive those Know Your Rights presentations, and they also receive legal screenings, which can be referred to as intakes. And these are supposed to be completed within 10 business days of the child's arrival in the shelter. Now, if the child is detained for long enough to be scheduled for court on a detained juvenile docket, the legal service provider will provide assistance, either as friend of court if allowed, which I mentioned earlier, or enter their limited representation for just that hearing. During their time in OR custody, children may also be assigned that Young Center child advocate that we mentioned, especially if there are issues with reunification or being stepped up to a more secure shelter. In some jurisdictions, there's also funding for legal service providers to provide that legal orientation program, LOP, which I mentioned, which is intended for sponsors so they can be informed about basic immigration procedures and the law. Sometimes these are offered at the LSP office and sometimes at the immigration court. Now I want to talk to you about all the different paths that an unaccompanied children's legal case can take while they are detained. So I'm actually going to start with the bottom half of the graphic first. So if a child can reunify with someone, such as a family member or friend, the shelter will, vet them and then hopefully approve and release the child to the individual. At that point, the child needs to seek an attorney to identify and apply for legal relief. This could be a nonprofit, this could be a pro bono attorney, but it could also be a private attorney who is paid. At this time, hopefully the attorney can identify them as eligible for legal relief and they'll start that process. But some children may want to request voluntary departure. This is when they want to return to their home countries voluntarily without getting a removal order. However, not everyone qualifies, and they are subject to certain consequences if they don't leave within the time frame established by the judge. It's still preferable to removal order because a removal order comes with a bar to re-entry for a certain period. Now, looking at the top of the chart, if a child can't reunify with someone because there's no sponsor for them or the sponsor just wasn't approved, there are two different programs they can enter. There's the Unaccompanied Refugee Minors Program, URM, and Long-Term Foster Care, LTFC. Again, these have different requirements. As mentioned before, LTFC used to require eligibility for legal relief. Now it doesn't even require that. URM, you have to either have already won legal relief to stay lawfully in this country, or you must be a Cuban or Haitian migrant, or be identified as a victim of human trafficking. And that's done through an OTIP letter. And we have more resources about that on our website. So we talked about this a bit before, but the average length of stay in OR custody can really fluctuate. Changes in administrative policies can increase or decrease that average length of stay. So looking at this slide, you can see in fiscal year 2017, the length of stay began rising and it peaked in 2020 when stringent requirements were imposed on potential sponsors. So during the Trump administration, OR was imposing additional requirements. They increased background checks and home studies. And this was really coupled with a dearth of fingerprint offices, appointments, and even officials able to do the home studies in person. So this really lengthened the time that children were spending in OR custody to an average of 102 days. So this is an overview of those policies that have really impacted the length of time it takes to release a child to an appropriate sponsor. So in April of 2020, ORR, ICE, and CBP signed what's called a Memorandum of Agreement, and it set out a process by which ORR would share biographic and fingerprint information from potential sponsors and any adult household members of that sponsor, and they'd share it with ICE and CBP. And DHS would then provide ORR with a criminal and immigration history of that potential sponsor and any adult household members. So and importantly, it did not place any limitation on how DHS could use the information they were receiving. So this really scared away many undocumented sponsors from completing the reunification process, and some sponsors were in fact targeted as a result of this memorandum. And this targeting of potential sponsors is likely closely linked to the reason why ORR capacity ballooned to up to over 13,000 children in OR care with an average length of stay of 102 days. Now, since March of 2019, OR started gradually rolling back some of the increased vetting of sponsors. And in June of 2019, they created a new category of sponsor that didn't require fingerprints before release. So that helps speed up the process of getting children released to their sponsors. Now, at present time, there are now more fingerprint offices and appointments and more staff assigned to do home studies. So the average length of stay has returned down to about 34 days. During this time, over the past few years, advocates did take to the courts over this problematic issue. So this case, Duchitanga v. Lloyd, dealt with fingerprint requirements for sponsors. As I said, the requirement was adding weeks, even months to the reunification process just to get these fingerprints appointed, completed, and receive the results back. And like I said, some sponsors were scared away from the process because of the way ORR was sharing information with ICE. So the ACLU of New York filed suit, and during the course of proceedings, the government lessened the requirements and opened up more sites to deal with delays. The case then settled and resulted in new deadlines. So the government must schedule fingerprint appointments for sponsors within 7 business days. And once that appointment takes place, the processing of the fingerprints must take place within just 10 business days. So that has really helped speed up the release of unaccompanied children. So this is another important case to be aware of, Garcia Ramirez v. ICE. And this case came about because of the treatment of age outs. So, age outs refer to children who turn 18 while still in OR custody before they got released to sponsors. Maybe their sponsor was denied for some reason, they couldn't find a sponsor, but they couldn't get into long term foster care or URM. And so, prior to this case, most of these children were being transferred from OR to ICE custody, to ICE adult detention. And ICE was not considering the least restrictive placement for these youth. So, in addition to the fact that CBP and ORR need to find the least restrictive placement for unaccompanied children under the age of 18, ICE is also required by law when these children turn 18 to consider the least restrictive placement for them now as young adults. So, on September 7th, 2022, the district court approved a settlement agreement in this case wherein the government agreed to dismiss its appeal and a permanent injunction became final. So now ICE, FOJC's field office juvenile coordinators, or just ICE officers who deal with juvenile cases, they must complete a case worksheet for every child that's approaching age out of OR custody. And they have to do an assessment of whether there's a suitable sponsor or a group home to place them in. So even if there was a sponsor that ORR denied because of ORR requirements, ICE is now required to consider that sponsor and whether they meet the requirements for ICE to release young adults to other adults. It also requires ICE to retrain its officers, fill out this new paperwork, revamp its training and policies with regards to age outs, and they have to provide monthly reports and documentation to class council on the rates of detention for age outs. The good news is class council will continue to monitor ICE's progress and compliance through September of 2026. And the number of age out transfers to ICE custody has dropped dramatically since this lawsuit. And the majority of age outs are now released to sponsors or group homes in the community. A similar category of children to be aware of is what we call age redetermination. So this is another facet of ORR protocol. Initially, this can come about because ORR or shelter staff become suspicious that an unaccompanied child is not, in fact, a minor under the age of 18. This can be because of information in the CBP file. This can come about for African and Asian children, especially who have to make the journey through South and Central America. We've been told that often they are forced to lie about their age, especially in Panama. They say they're 18 or older just to get through the country. But sometimes this can then cause suspicion once they're in US ORR shelters about whether they're an adult or a child. Sometimes suspicion comes from things said by family members on calls that shelter staff workers think are just not adding up. And honestly, a lot of this does come down to those implicit biases that we talked about back at the beginning of this recording. You know, many children that are put through this process are from African countries, and it can be just because staff in the United States may not be accustomed to these different groups and ethnicities. Some may simply be basing their suspicion off physical appearance. So once there's this suspicion in ORR, the next step is an investigation. ORR often sends the children to dentists to get a dental exam, which purports to show the actual age of the child. However, studies in the medical community have shown that these are incredibly unreliable and not adapted to non-white children of other races. In addition, staff will sometimes do their own digging on social media profiles to try and collect evidence to show that the child's really an adult. Sometimes the consulates will get involved. They will try and get certified documents, such as a birth certificate, to determine the child's true identity and age. So an official determination is then made by the FFS, the Federal Field Specialist from ORR. If they redetermine the child's age and determine the child is 18 or older, they are transferred to ICE custody. Unfortunately, the youth are then treated as if they were an adult entering at the border or port of entry. If they have not already filed for legal relief, like asylum, they must then pass a credible fear interview or they will be expeditiously removed. The good news is that advocates can get involved and intervene in this process. So as soon as legal staff are tipped off that an investigation is happening or just that there's suspicion, advocates should get involved on behalf of these children. They can suggest staffing calls with the shelter caseworkers and the FFS, where everyone can get together to kind of hash this out, and they can argue on behalf of the child. LSPs can do their own investigation. They can look on social media. They can talk with the child. They can refer that child to the Young Center. So they also have a child advocate fighting on their behalf. Legal staff can gather evidence, including affidavits from family members, to support the child's stated age. And they can conclude all this by writing a letter to the federal field specialist making their case. So advocates have been successful in the past to prevent the age redetermination and the transfer of the youth to adult detention. So the majority of children are released to sponsors, and I think I mentioned this before, but the top states are Texas, California, Florida, and New York. Texas received 19,000 children in fiscal year 2022. California and Florida received about 13,000, and New York had about 8,000. And this map and chart on the right shows you even the top counties that receive children. You can see Harris County in Texas, Los Angeles County in California, Miami-Dade in Florida. And so it's really very concentrated where the majority of children are going. Now, long-term foster care. This was mentioned before. This is for children without a viable sponsor. And you can find guidance on this in the ORR policy manual online in section 1.2.6. So an unaccompanied immigrant child may be placed in long-term care setting, such as community-based foster care homes or extended care group homes. A child is a candidate if they do not have a viable sponsor, and they're under the age of 17 and a half at the time of placement. This is why some children end up aging out of OR custody. They don't have a sponsor, but they're over 17 and a half. Many programs require this, so there's enough time to get lawful status before they turn 18, but some programs will make exceptions. And finally, as mentioned before, they no longer need to be found eligible for legal relief by a legal service provider. The Unaccompanied Refugee Minors Program is similar but different. So initially, only unaccompanied minors with refugee status who were identified overseas were eligible for and admitted to the URM program. But over time, Congress expanded eligibility to other populations. So in addition to refugees, this included children who had won asylum. This is children who are Cuban or Haitian entrants, so they don't have to have won any sort of legal relief. This is open and eligible for children who have approved SIJ status. This is open for children who are victims of human trafficking and have that OTIP letter from the government, and also children who are U status recipients. So with the exception of those refugees referred by the Department of State from overseas, ORR requires all eligible children within the United States to go through an application process to identify the best placement and services for each child. And the program will take into account their best interests as well as availability of spots open. And there are URM programs in certain states around the country, not in all states. So you can see here on the map, we've got Texas, California, Florida. So this won't necessarily always be in a state where your other shelters are found. Finally, I want to mention unaccompanied Afghan minors, or UAM. So prior to 2021, very few Afghan children entered the United States as unaccompanied children. But in 2021, during the mass evacuation from Afghanistan, many unaccompanied children entered the ORR system. Many of these children were separated from family during the chaotic evacuation at the Kabul airport. Others traveled with extended family or friends, but were not allowed to stay with them because they weren't their parent or legal guardian. And because the OR system was really not used to this population, there were many road bumps in those early days. But over the past 2 years, most children have either been released to a sponsor or placed in LTFC or URM. However, it really took many months and sometimes over a year for these UAM to get into these foster care programs because there simply weren't enough spots, not enough beds around the country, because no one had envisioned that this mass evacuation would occur. Typically, the typical population was Central American children coming into the OR system, then being transferred into LTFC or URM care. So this really just changed the landscape. This large group of children came into a system that was not prepared for them. But at this point, advocates have now been working with UAM for the past 2 years. Most are applying for asylum or SIJS, and some are even at the point where they've already won their asylum cases. So that is the end of the introductory presentation. I hope you learned something today that you'll take with you in this work, and we hope you stay connected with SELA. Feel free to reach out to us on technical assistance on a case you're working on. We also have a newsletter you can join, and we have our website where you can learn more about us and view our resources and recorded training. You can sign up to receive our monthly newsletter. If you have your phone handy, you can scan this QR code. If not, you can go to our website to sign up. And this is a new monthly newsletter that contains updates from the previous month regarding policy, litigation, new resources, and past and upcoming trainings. We also like to celebrate the work that everyone does. So if there's ever anything in your work you would like us to know and include in the newsletter, please email us. You can reach us at SELA@avacela.org to share those celebrations. SELA also has a pro bono platform. We post resources for pro bono coordinators and pro bono attorneys. We also host a pro bono platform where legal service providers around the country can post cases for pro bono attorneys to take. And if you're considering becoming a pro bono attorney, please check out those available cases. We also have a quarterly pro bono newsletter, so if you're interested in that, you can scan the QR code on the screen. Finally, we hope you follow us and connect with us on social media. Scan any of these QR codes to connect with us. And thank you so much for watching this training on an introduction to working with immigrant children.